So I'm back reading the Illinois State Constitution. Defamation, the second sentence of this section dealing with libel, is somewhat outdated, carrying over from the 1870 Constitution. A series of decisions by the U.S. Supreme Court, beginning with the New York Times Company versus Sullivan, 1964. I disagree. It's not outdated. Have held that the U.S. Constitution's First Amendment requires public figures who sue for libel to demonstrate that the statements were false and made with either knowledge of their falsity or reckless disregard for whether they were true or false. That I would agree with. The Illinois Supreme Court has held similarly as to public figures and persons involved in a matter of legitimate public interest, such as medical quackery or tenure decisions at a public university. Even as to private figures, the U.S. Supreme Court has held that the burden of showing falsity of defamatory statements on matters of public concern must be on the person defamed. The Illinois Supreme Court in 1984 held that the standard of good motives and justifiable ends was still appropriate in prosecutions for criminal libel of a private person. The court emphasized that the criminal libel law at that time applied only to statements containing fighting words that threatened to breach of the peace. But that law was repealed in 1986 and was not replaced. Section 5, right to assemble and petition. The people have the right to assemble in a peaceful manner, to consult for the common good, to make known their opinions to the representatives and apply for redress of grievances. Peacefully assembly and a petition are also protected by the U.S. Constitution's First Amendment, which applies to states through the 14th. Although reaffirming the right to assemble peacefully in places that are routinely open to the public, Illinois courts have upheld arrests for demonstrating inside public buildings after normal closing hours, using force to stay in a college building after being told to leave, and attempting to march to an area where police have forbidden marching due to reasonable fears of violence. Section 6, searches, seizures, privacy, and interceptions. The people shall have the right to be secure in their persons, houses, papers, and other possessions against unreasonable searches, seizures, invasion of privacy, or interceptions of communications by eavesdropping devices or other means. No warrant shall issue without probable cause, supported by affidavit particularly describing the place to be searched and the person or things to be seized. As it stands now, I still look at what happened over 2 years ago to my 2 minors, is that we, the people of Illinois and the United States of America, thought that Shane Tyler Propert was a legitimate authority, either God himself, the governor, a judge, or someone else, who could come in here and seize my 2 children out from underneath me. And then on top of that, I had a New York State court order that said I was, the custodian of the minors, the children. The Illinois Constitution's search and seizure provision are based on the Fourth Amendment to the United States Constitution, but in 1970, Constitution added a guarantee against invasion of privacy and eavesdropping. Illinois courts have repeatedly held that this section protects only against government searches and seizures, not against actions by private persons that were not taken at the instigation of police or other governmental personnel. And that is wrong, too. But this section does not restrict even government personnel in gathering information from public sources. Examples of actions by government that have been held not to violate this section are using public knowledge for an arrest, even though the records of the arrest have been expunged. Observing a gun openly visible in a car. The arrest on an expunged case is unconstitutional. Pulling someone over because they have an open gun in their car is unconstitutional too. Or having dog sniff for drug scents coming from airport luggage, observing the vehicle identification number of an automobile, and observing contraband while in a residence for another valid purpose such as rescue. Illinois appellate court cases have upheld a statutory requirement that persons convicted of sex listed in the statute give blood samples for testing. But somehow we the people didn't follow through with that, especially in Illinois. New Hampshire, as far as I know, didn't either. And not New York. On Shane Tyler Propert Sr., born the 6th of March, 1973. Yeah. Anyways, that's it. Some things to ponder about, we the people, Illinoisans. Yes, we're Illinoisans because we're from Illinois, the state of Illinois. So we call ourselves Illinoisans. Peace. Enjoy your great Constitution, Illinois, and the United States of America. Hooray for the red, white, and blue. Boo, 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 boo.